Did you know that when you bring a lawsuit against your careless doctor, when you are giving a deposition and you are asked questions, it is not the time for you to go ahead and tell the attorney, the defense attorney, everything that happened to you? You want to know why? Come join me on this walk through this deserted island here on St. Martin as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your careless doctor and that you claim that his carelessness caused you harm and injury. Well, now the doctor denies all of your allegations. During the course of your lawsuit, there will be an opportunity for the defense lawyer, the attorney who represents the doctor whom you have sued, to question you. And this will take place in your attorney's office, in his conference room, and there's no judge there, there's no jury there, but there will be a court stenographer there to record all of the questions that you are asked and all of the answers that you give. So the defense attorney will be there, your attorney will be there, you will be there, and a court stenographer will be there. Okay, you have in your mind that this is now the opportunity to go ahead and tell the defense lawyer everything the doctor did wrong, everything that happened to you, every little single detail that happened to you. You believe in your mind that this attorney needs to know all those details. Well, I want to share something important with you. The reality is that no, your deposition, which is what this question and answer session is called, is not an opportunity for you to tell the defense attorney every single thing that happened. That's not what this is designed to do. There will be instances where you will be asked open-ended questions such as, Mrs. Jones, tell me what happened then. And now you can explain to the defense lawyer exactly what happened in that instance. But it is not the opportunity for you to go ahead and tell him every single detail. It is not an opportunity for you to go ahead and tell a narrative story from the beginning till the end. That's not how it works. That's not how any of this works. Instead, the deposition is designed to answer the defense lawyer's questions. Now, that's a very important distinction, which means if the defense attorney fails to ask appropriate questions, well, guess what? Then he has lost the opportunity to learn critical information from you, to learn critical details about what happened to you. If the defense attorney fails to ask a lot of follow-up questions, it is not the chance for you to go ahead and fill him in on all the details. Why not? Because that's not what this is designed to do. The deposition is designed to allow the opposing attorney to go ahead and question you to learn what happened, to learn in your own words exactly what occurred, to learn what injuries you suffered because of the doctor's carelessness, and to find out how your injuries have affected you on a daily basis and what you are no longer able or capable of doing and how you are disabled. That's critically important. So, when an attorney asks you a question such as, hey, Mrs. Jones, tell me what happened. Well, that's your green light to go ahead and start filling in some details. But if the attorney is asking pointed, focused questions, now you have to answer only those focused questions. Don't go off on tangents. Don't start telling him stories about things that have nothing to do with the question that he asked. This is critically important. And by the way, this applies not just to medical malpractice cases, but also to accident cases, to trip and fall cases, to other cases involving personal injury that happened in New York. So why do I share this quick information with you? I share it with you because I have a few minutes. My wife is busy picking shells on this deserted island here on the French side of St. Martin. And I realize so many times that an injured patient, when they're coming to a deposition, they think this is their chance to go ahead and tell the defense lawyer exactly all the details of what happened. And when you're being asked questions by the defense attorney, pay close attention to the questions you are being asked. In most instances, they're going to be very detailed and very focused questions, which you'll be able to answer. But remember, that's not the opportunity for you to go ahead and start talking about every single thing. So when do you have the chance to go ahead and answer and give lots of details? Well, I'll tell you when. When the attorney starts to ask you questions about how you're doing now, about what problems you have now, about those things that you can no longer do. Now, why do I say that's a great opportunity to tell him in detail? I'll tell you why. Because the attorney doesn't live with you. The attorney doesn't see you each and every day. The attorney doesn't realize what kind of pain you have. All the attorney has is copies of your medical records from your treating doctors. And that's two-dimensional. But now, when he hears from you exactly what you can and cannot do, now he begins to get a better idea and a better perception and understanding of exactly how these injuries have affected you. You know, I realize you're likely watching this because you wanted to see the beautiful scenery where I was shooting video today. Either that or you really wanted to learn about how these types of cases work. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.